the Chief Judge presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Well, good morning, everybody. Welcome to an oral argument session of the 5th District Court of Appeal. We've got 3 cases on the docket today. Let me introduce the other members of the panel. I've been introduced to you already. To my right, from Marion County, we've got Judge Brian Lambert. And to my left, we have the fortune of having an associate judge with us from Seminole County, Donna McIntosh. We have 3 cases on the docket this morning. 2 of them are civil cases. In those cases, each side will be allowed up to 20 minutes each for the argument. I have a default 5 minutes for rebuttal, but that's flexible. I'll give you whatever amount of time that you would like for rebuttal. Just let me know when you begin the argument. Then the third case is a criminal case. They will get 15 minutes each on that. We are going to take a break because we're going to have a panel change after the second case, and so between the second and third, on the third case rather, so between the second and third case, we're going to break, and then we'll go and meet the lawyers, if you'd like, for coffee back over by the library. So we've got, we're going to take them a little bit out of order because I think a lawyer was running late. So we're going to begin with TRUSTCO Bank versus Thomas Webb.
Are they late? I mean...
Oh, are you here? Are you here for STOPA?
I am, sir.
Oh, okay. Well, then I guess if you guys are situated, we'll go ahead and do them in the order that they're in.
I'm fine if the other case goes first.
Would you prefer that?
I would, Your Honor.
Okay.
We had some exigent circumstances to deal with.
Okay. All right. So TRUSTCO Bank versus Webb. All right, let me. All right, Mr. Johns, whenever you're ready.
Well, good morning.
Good morning.
I'm Jeffrey Johns. With me is Eric Johns. We represent TRUSTCO Bank.
Is he related to you?
We're brothers.
Oh, all right.
Yes, we are related. We think this case comes under the heading of that old adage that no good deed shall go unpunished. Paul Webb is a 90-year-old infirm man. Paul Webb has been a customer of the bank for approximately 50 years in New York. TRUSTCO Bank's had a good and long relationship with Paul Webb. All of a sudden, Thomas Webb secretly removes his 90-year-old ill father out of New York and brings him to Florida. And after leaving New York, Thomas Webb, the son, learns that the New York court has entered an order.
Assistance to you, we all are familiar with the facts of the case.
Well, as you know, not only was an order entered making David Oliver, a stepson, the guardian of the person and property, but that court went further and it entered a specific injunction against Thomas Webb and some other people from accessing Paul Webb's papers and assets.
Did you mean temporary guardian?
He was a temporary guardian, but if you read the order, it says that it gives to Oliver all of the powers over the person and property of Paul Webb. So it is a guardianship order, and it says that Thomas Webb and others cannot have access or are enjoined from Paul Webb's property and his money. Now, we're a bank chartered both in New York and in Florida, so we have offices in both places. And here's the key point. Thomas Webb then sneaks back into New York, goes to a TRUSTCO branch, and convinces the branch manager to transfer $20,000 out of Paul Webb's account into Thomas Webb's account. TRUSTCO didn't know of the injunction at the time. It had not yet been served with the papers, but Thomas Webb did. A few days later, we are served with the papers.
Let me ask that, there wasn't a motion to suspend the power of attorney filed, correct?
No, there wasn't. And there's...
Isn't that what 774-3203 requires?
No, because the first part of 709.2101(1A), the first part of that order, of that statute, says that upon the appointment of a guardian, partial or complete, the power of attorney terminates. If you then go to the third portion of the statute, it says that if someone files a motion to have someone determined to be incapacitated, but the order has not yet been entered, then in order to suspend the power of attorney for a son or certain other relatives, you've got to file the verified motion that is called for under 744-3203. And if you go to 744-3203, you'll see that section is entitled Suspension of Power of Attorney Before Incapacity Determination. So the first part of the statute says once an order gets entered appointing a guardian, the power of attorney terminates. But if you just file a motion to have somebody determined as incapacitated, but the court hasn't acted on it yet, that power of attorney is still in full force and effect unless you file this verified motion. And that's not our case. In our case, the New York court got the petition one day and within a couple of days entered the guardianship order and the injunction. Now, when TRUSTCO found out what had occurred, that there had been a guardianship order entered and there had been an injunction enjoining him from doing the very thing he had come into our bank and done, they smelled the possibility of exploitation of a longtime customer, and they reversed the transaction. And so, in return for this good deed of trying to prevent a longtime customer from being exploited as 90 years old and infirm, we get slapped with a lawsuit for conversion and negligence.
The statute says that if the agent named in the power of attorney is the principal's parent, spouse, child, or grandchild, the authority under the power of attorney is not suspended unless a verified motion in accordance with 744-3203 is also filed. What's the significance of that language?
Well, what the significance of it is, and we're looking at Section 3 of 709.
Oh, no, I want you to address the specific language of 744-3203. It says that if it's a parent, spouse, child, or grandchild, the authority under the power of attorney is not suspended unless a verified motion in accordance with that statute is filed.
But what I'm saying to you is the only time that section kicks in is when 709.2109 Part 3 applies, which is where someone applies to have someone determined to be incapacitated, but they have not yet been, a determination has not yet been made. And the statute at the top of it says that it is to determine what happens after a petition is filed, but before a determination is made. You never get to Section 3 if Section 1 occurs. Under Section 1, a power of attorney terminates when the principal is adjudicated totally or partially incapacitated by a court. And it doesn't say a Florida court, it says a court. So you never get to Section 3 and you never get to 744-3203 under our fact situation. Once that New York court determined to appoint a guardian and to enter the injunction, 709 Part 1C is the applicable statute.
Does your argument change if there was no injunction, as you're referring to, issued by the New York court?
No, I think the argument would be the same. The injunction is just sort of icing on the cake. The power of attorney would have terminated anyway if the court had just entered a guardianship order with no injunction.
So when you have a temporary guardian appointed, that suspends the power of attorney that was executed in favor of, in this case, a child, even without the motion that's required to be filed?
Yes, yes, because if you look at that temporary guardianship order, it's very extensive, and it really takes away all of Paul Webb's rights to manage his own affairs and his own property, and gives them all to David Oliver. It is a pure guardianship order.
So if a stepson comes in and hadn't seen the father for 20 years, gets a temporary guardianship ex parte entered, and the person, the son, who's always taking care of the dad and has the power of attorney, that temporary guardianship trumps, even though there's been no determination of incapacity of the father?
Well, I think so, and of course all this occurred in New York. They have a little different procedure than we do, but all this happened in New York. The court entered the order, and the court set up further hearings in order to decide, everybody gets served and decide whether this temporary guardianship should be made a permanent guardianship. But yeah.
Which it wasn't, if I understand. And then,
No, because at the time the guardianship order was entered, nobody knew where Paul Webb was. Paul Webb had been secretly spirited out of the state of New York. In fact, it's in the record that there were police reports made reporting him as a missing person or a kidnapped person, and they only...
By who?
Huh?
Who made those reports?
The stepson.
Stepson. Okay.
The stepson, and the police department of one of the towns in which he lived, the father lived, apparently contacted Thomas Webb in Florida, let him know, found out that he was in Florida, and advised him of the existence of the guardianship order. So the record's pretty clear that when Thomas Webb went into our bank, he knew there was a guardianship order. I've pointed out that he didn't tell the folks at the bank about this guardianship order, although he knew it, and he was asked at deposition why he didn't tell them about it, and he said it wasn't relevant and it was fabricated. So he hid from the bank that the guardianship order had been entered. He hid from the bank that he was enjoined, and he didn't go into a TRUSTCO branch in Florida. He went into a TRUSTCO branch in New York where he was clearly under the jurisdiction of that court, and that injunction was clearly in effect with respect to Thomas Webb in the state of New York, and he knowingly had the money transferred in violation of the injunction.
So the relief that you seek from us today,
I'm sorry?
the relief that you seek is what?
Well, I think I've said that there are at least 6 justiciable issues in this case. The trial court blew right through those, even though discovery was pending and Thomas Webb had refused to answer a bunch of questions that we had. We think it's very clear there were 6 justiciable issues that kept summary judgment from being granted, and we want you to reverse it and send it back and tell the court to let us conclude our discovery and let the case proceed normally, either to another hearing or to a trial. And then, of course, the icing on the cake in this situation is not only did we get a summary judgment entered against us, but then the court very quickly, while our motions were pending to compel discovery, found that having entered a summary judgment prematurely in our view and truncating our ability to complete discovery, then found that we had no valid defenses and hit us with a 57-105 sanctions award, attorney's fee award. So this is, like I say, this is no good deed goes unpunished. We try to keep the elderly father from being exploited by somebody here, and then we get hit with a conversion count, a negligence count, a summary judgment prematurely.
May I interrupt for a second? What was the bank's legal authority to reach into the account of Thomas Webb once it honored the power of attorney?
What was its,
Legal authority. Under what authority did it have to reach into Thomas Webb's account?
because the power of attorney had been terminated and therefore was in no force and effect.
Wasn't that a matter for the courts to decide?
Well, that's the issue of this case. That's one of the justiciable issues. The first question is, did the power of attorney, did the court order in New York terminate the power of attorney, and was the transfer invalid?
I don't know that that's an issue, because the bank, your client decided that it was a valid power of attorney and acted upon it.
The second issue is the injunction. Thomas Webb acted in violation of an injunction of a court of New York in the state of New York.
And would that not be a decision for the courts to decide, for the temporary guardian to handle?
Well, it's a justiciable issue in this case. It's a case that it's an issue that deserves to be fleshed out and determined in this case. This is not a frivolous issue. It's an important issue.
Let me ask you, so if I go to Walmart and I steal $1,000 from Walmart and I put it into a TRUSTCO account that I've lawfully had, and you guys honor my deposit, and you happen to have Walmart accounts too, and you read in the paper the next day that I've been arrested for possibly stealing money from Walmart, do y'all just get to go ahead and say, well, we're going to, theft's a bad thing too, taking advantage of the elderly's bad. Can you just take the money out of my account and give it back to Walmart because you read it in the paper?
That's factually different. I'm dealing.
Oh, it is? Is that factually?
No, it is in this case because you understand the money was transferred from.
I know it's a hypothetical, counsel.
Yeah,
that's why I gave it to you.
But I'm saying I think it's apples and oranges. Here,
Well, then
the money.
just tell us quickly, what is the legal authority for TRUSTCO to reach into Thomas Webb's account and take the $20,000 back?
The legal authority is we were undoing a transaction that improperly occurred in the first place because it occurred in violation of a court order in the state of New York.
Isn't that for the court to decide whether that's an improper transaction?
And that's why we're in a court to have it decided. But it's not a frivolous issue.
I think the point being made is that it's not like there's an interpleader, and it's not that you've presented it to the court for a determination. It just seems that TRUSTCO unilaterally made a decision, and in their view, it was an improper act, and took it upon themselves to make that ruling rather than let a court make the ruling.
But you understand, this was money that went from one TRUSTCO account to another TRUSTCO account. This was money that was still in the bank. This wasn't money that was somewhere else. And
Why is that? I don't see the significance of that. Okay, it's in the bank, but it
allowed you to engage in self-help. It allowed your client to engage in self-help, correct, without allowing the legal course to proceed, which would be the temporary guardian who was required to marshal the assets, going to a court of law and saying, guess what? They just illegally took $20,000 out of his account.
I'm sorry.
And then the court could have addressed it, and your client would not obviously be standing here today, correct?
It allowed us to go back and preserve the status quo as
Why would a third party want to do that? That's the job of the temporary guardian. Why would the bank's a third party to that issue?
No, I don't think so.
What if the son had taken gotten the $20,000 from Dad's account and put it in his own TRUSTCO account, and then the next day took $20,000 out and put it in the Chase Bank account, and then TRUSTCO becomes wind of, well, that maybe this shouldn't have happened. You can't go to Chase and say, oh, by the way, we're going to right a wrong here. Chase, could you give us the money out of that account? Obviously.
If the money had gone out of TRUSTCO Bank, certainly that would have complicated things and would have made it difficult to undo the transaction. But in this case, Thomas Webb, in violation of the court order and the injunction, came into our bank and misled the bank and got the bank to transfer the money. And once we learned of the injunction, we then went back and preserved the status quo.
All right, you're into your rebuttal time. Would you like to reserve that?
Good morning, Your Honors. Lisa Patton on behalf of the appellee Thomas J. Webb. This case is very simple. My client, Thomas Webb, opened an account in a Lake Nona branch of TRUSTCO Bank. He deposited $600 into that account. That was in December of 2015. Both he and his father had a long-term banking relationship with TRUSTCO Bank. 45 days later, approximately, he goes up to New York and uses a power of attorney that he had obtained in Florida, that his father had executed, giving him authority to transact all of his business. He takes that power of attorney, goes to the TRUSTCO Bank branch in Schenectady, and withdraws $20,000 from his father's account. And he transfers it to his account in Lake Nona. It's a transaction that was authorized by the bank. Then, 4 days later, the bank somehow discovers that a guardianship action had been filed by the stepson, David Oliver. And when they find this out, for some reason, the bank decides that David Oliver is in the right, and the natural-born son of Paul Webb, my client, the appellee here, is in the wrong. And they jump to the conclusion that there has been wrongdoing and that they need to help avoid exploitation of their client, which is...
The David Oliver, is that the lawyer David Oliver, or is that unrelated?
David Oliver, Your Honor, is the stepson.
I understand. Is he a lawyer?
I believe he is a lawyer. I don't know exactly the details of that. I don't think any of that is in the record, but I understand that he is. Things were said at the lower court about that, but he is the stepson. He tried to get a power of attorney and did over Paul Webb, the father, and that power of attorney was terminated when my client obtained the power of attorney in Florida in October of 2015 and used that power of attorney to go up and remove the monies from the account that were in Schenectady, because my client, and this is in the record, had learned that David Oliver was utilizing his father's assets and going through them very rapidly, had also made plans unbeknownst to anybody to put his father in a nursing home, had already signed the applications, hadn't discussed it with Paul Webb, hadn't discussed it with any of the children, so was making all of these plans. And when my client finds this out, he says, "Dad, do you want to go into a nursing home?" The father, who is a lawyer, was a very well-known patent lawyer up in New York, who was still of sound mind completely, said, "No, I don't want to go into a nursing home. I want to move down to Florida where my grandson is, and I'll live there."
I'm having that same fight with my kids.
Yeah, exactly. Well, the issues in this case, though, Your Honor, are whether the bank was overreaching when it removed those monies from my client's account in Lake Nona, and they did overreach. They had no legal authority, any legal basis to remove those funds. Once that settlement became final, they could not go back in and reach in and say, "Oh, we think that Tom Webb, that you are exploiting your father, and we're going to take the side of David Oliver," which is what they did. They put themselves in the middle of this guardianship dispute, and they had no basis or reason to do it, which is why we filed an action.
In your view, what should the bank have done?
The bank should have waited to see if a claim was going to be made against it for some type of wrongdoing, because what we know the bank is asserting is that when they found out that the guardianship action had been filed, they take the position that Thomas Webb violated an injunction order. Then they say that the power of attorney was invalid because of the filing of the guardianship action, so therefore they could go in and reverse the transaction. As Judge McIntosh pointed out, there is no legal basis to do that. Once the settlement became final, the bank was stuck with that transaction. They should have waited to see if David Oliver would have made a claim against my client and/or the bank for some type of wrongdoing. But that never happened. Instead, the bank inserted themselves in the middle of that dispute and took sides. They took the sides of David Oliver. And the case law and the applicable statute here clearly shows that the filing of a guardianship action does not terminate a power of attorney. The statute that is applicable,
But
which
is that really an issue for this court at all?
it should not be, because the statute which
They honored it, the bank honored it.
the bank honored it, yes. And so once it's honored and it becomes final, even if they had found out the power of attorney was forged, you can't go back after the fact and undo a final settled transaction, because that's not what the law allows them to do. The UCC is very clear about that once these settlements become final, the banks lose the power to reverse these transactions, and when they do it, they subject themselves to liability. So, but I think it's important to clear up what Mr. Johns was saying, because he's incorrect when he says that the filing of the guardianship action and the entry of the order there terminated the power of attorney. It just simply did not do that. The only way that a power of attorney is automatically terminated is if there's an adjudication of incompetency or incapacity. And the order that was entered by the New York court did not make that finding. It's attached to his brief as an appendix.
The only thing in the record is a temporary guardianship order, correct?
Exactly.
We don't have a final adjudication.
We don't. And when you read that temporary order, it doesn't make any finding of incapacity. All it does is appoint David Oliver to allow him to look into the medical records of his stepfather, to start looking at his assets and protecting them.
Partially assets.
Exactly. But
Which
it
would have
does
allowed
not.
him to file a lawsuit to get a court to intervene if he thought that assets were beyond his reach that belonged to the grantor of the power of attorney, correct?
Yes, exactly.
The temporary guardian could have jumped in and sought relief from the court system.
He could have, yes, but he ultimately could not, because that temporary guardianship order was dismissed, and it's very important to know why it was dismissed, because it was never properly served upon Paul Webb, because he had already moved to the state of Florida at the time it was filed. So there was a huge jurisdictional problem in the state of New York. The court up there recognized that. It wasn't timely served. The petition and the order was dismissed. It had to be refiled again. It was actually refiled on the same day we filed our action against TRUSTCO Bank in Florida. So David Oliver filed a second petition for guardianship up in New York. That was again dismissed ultimately because in the meantime, my client, in order to put an end to all of it, filed a guardianship action down in Florida, and Judge Rodriguez entered a temporary guardianship order. And once the New York court saw we don't really have jurisdiction over these matters, dismissed it all. But what I think is also very important to point out is...
At any point in time, was there a finding of incompetency?
Never. Never. Not by the New York court. And I think what's
how about
also...
by Florida?
I'm sorry?
How about by Florida?
I believe there's a permanent guardianship order that was entered at this point by Judge Rodriguez after the filing of our claim. But at the time all these events were taking place, there had never been any incapacity or incompetency finding. But I think it's also...
Just for the backstory, I know it has
Yes.
nothing to do with this case. Who was appointed as the guardian?
Tom Webb. That is in the record. And also, I want to make it clear that Mr. Johns continues to argue that TRUSTCO Bank was justified in removing the monies from Tom Webb's account because there was an injunction against Tom Webb at the time he made the transfer. That is absolutely false. There may have been a temporary order that was entered naming and making mention of Tom Webb, but my client and the appellee here was never served with any type of order enjoining him from doing anything with regard to his father. It just simply did not happen. So for the bank to argue that the appellee was enjoined and then somehow secretly convinced the bank to do something that he knew he should not have been doing is just simply false. There is nothing in the record that supports that accusation. The only thing in the record that suggests my client knew about an order that was entered is the fact that he called the police when someone took his father's car, and the police told him, yes, there's been a guardianship action filed and there's an order entered. That's all that's in the record. It doesn't say that my client knew what the order said or that it even mentioned him in any capacity. So for the bank to accuse the appellee of some type of covert action and fraud upon the bank is simply unsubstantiated and it's false. There's nothing in the record to support that. So what happened here was when we file the action for conversion and negligence, the bank asserts these affirmative defenses of, oh, there's a guardianship action pending in New York, it invalidated the power of attorney, and therefore we were in the right to do what we did. We moved to strike those affirmative defenses right out of the box. The lower court granted that motion to strike. They filed an amended answer, asserted the same type of defenses, again saying somehow that the power of attorney was no longer valid. That's when they brought in the statute saying, well, it was suspended and or terminated by the filing of the New York action, which is false. That's not what the statute says.
You think that there has to be a motion to suspend the power of attorney file?
Yes, exactly. Because there was no automatic termination, because there was no incapacitation finding in New York at all. So the next step is, okay, there will be a suspension of a power of attorney when a guardianship action is filed. And the important thing also to note is before July 2015, the statute read where a guardianship action filing did automatically suspend a power of attorney. And the reason why it was amended was because there were so many abuses. People were filing these guardianship actions all the time in order to suspend powers of attorney. And so the legislature understood that the abuses were rampant, and they made the special exception, which Your Honor noted, that in order for a guardianship action to be, or a power of attorney to be suspended because of the filing of a guardianship action, you have to file a motion when the power of attorney is the next of kin, a mother, a father, a child, in this case. And no motion was ever filed by TRUSTCO Bank. The lower court recognized these things. We continued.
Why would TRUSTCO file anything anyways?
TRUSTCO,
Party, why would they have filed
right,
that motion?
they would
never
not
file that
have.
motion.
They should never have injected themselves into this case. But if you look in the record, it's clear that someone from David Oliver's camp, some lawyers, got a hold of the bank and convinced them to do this.
To engage in self-help.
Yes, because when my client went to his bank.
And is that in the record?
I'm sorry?
Is that in the record?
Yes, it is, Your Honor. It's in the record. When my client went to his bank to withdraw the monies, to actually try to take $2,500.
That the bank apparently had been convinced that there was
A problem.
right, a problem, but the source of that knowledge was less than clear to me.
Well, from the record, I believe it, and it's based upon what my client was told when he went to remove $2,500 from his account. He was given the name of, they told him the monies have been removed, call this law firm up in New York. And it was the law firm that was representing David Oliver. So that's the only connection we know that somehow David Oliver's lawyers convinced TRUSTCO Bank to do something that they weren't legally authorized to do.
I guess if your client would have opened an account in his name as attorney in fact for his father, probably would have calmed the bank down.
Perhaps.
But when he put it in his own personal account, that probably set off, and then with whatever, we don't even know what information they got.
We don't know.
But then with whatever information they got, and then they see it in a personal account,
Right.
I'm sure that red flags were flying for the bank.
Yes, and I agree, because throughout these proceedings, the bank has continued to say, hey, we're doing the right thing here. We just want to protect
No
Paul
good
Webb.
deed goes unpunished.
Yes, but that's not their position here. And they continued to assert it in the lower court. They tried to transfer this civil action into the probate court when Tom Webb, the natural son, the appellee here, opened a guardianship case, tried to transfer this case into the probate court. That was denied. Then, to try to get in the back door, they filed a motion to intervene in the probate proceedings. That was denied. So that's when we put them on notice. We are going to seek fees against you if you continue the defense of this claim. Return the monies to my client. They continued to defend the action. We filed our motion for summary judgment. The lower court granted that motion. The law is very clear that there is no legal authority to allow the bank to do what it did. And so the lower court granted our motion. After discovery, my client was subjected to a 3-hour deposition. He answered every question that you could imagine until I directed him not to answer questions regarding what he was doing as guardian for his father in the Orange County proceedings, and or to discuss settlement offers that were being discussed with him during his deposition. Those were the only questions that he did not answer. Everything else was answered. And the lower court had a motion that was presented to it prior to the motion for summary judgment to say, hey, slow this down because we haven't completed discovery. Judge LeBlanc said, no, we have completed discovery. This motion is going forward. He heard everything. We had a very lengthy motion and hearing, and after hearing all of the evidence and considering all of the arguments, the judge granted summary judgment. And then we brought our motion for attorney's fees up before the court because it has always been my opinion that there was no legal basis to the defenses that were being asserted by the bank. And 57105 is very clear. If the client and the attorneys know or should have known that there is no legal basis to these defenses, they cannot proceed. And the statute uses the word shall for a reason. They're trying to impose a mandatory penalty of attorney's fees when an action is continually litigated without any basis. My client was forced to pursue these claims for a very long period of time. He incurred fees that were in excess of the amount that was being litigated. That shouldn't happen. But the lower court recognized that in these situations, that's what the 57105 statute is utilized for, to correct these type of injustices. And the injustice here was TRUSTCO Bank continually trying to say, hey, I'm just protecting your father against you. That was absurd. He didn't need to be protected. That's what the guardianship actions were for, and that fight was being fought in a different venue. So the bank knew this at the onset, that they were going to be subjected to fees if they continued. They did not care. They continued, and Judge LeBlanc granted our motion for attorney's fees. So this morning, I asked the court that you affirm the lower court's decision. It was sound, it was well decided, and it was based upon all of the evidence and the case law that was applicable. Thank you.
All right, thank you. All right, Mr. Johnson, you have just a little bit,
Just a few
under
minutes.
3 minutes.
We think we're right on these issues, and Ms. Patton thinks that her client is right on these issues. But as an example, we have spent most of this time arguing about the interplay of 709.21091 and the third section of that statute. Which one applies in this case? And I would say to you, that alone is a justiciable issue in this case. The fact that a whole bunch of judges and a whole bunch of lawyers disagree about what these two sections of this statute may mean, whether the entry of the order in New York creates a guardianship and terminates the power of attorney, or whether it doesn't, is in and of itself a justiciable issue in this case. And it deserves the opportunity to be fully considered, fully discovered, and then a decision made. What we've said is, this case was truncated. Now, we think we're going to win if we go back and get a chance to finish our discovery. But even if we lose, all of these things are justiciable issues. Did the court order in New York terminate the power of attorney? Did the injunction in New York prevent Thomas Webb from accessing the money in TRUSTCO Bank? And did TRUSTCO Bank have the right to reverse that transaction? Have they shown a cause of action for conversion or negligence? Can they get summary judgment when discovery is not completed in the case? All of those are justiciable issues. And whether we win or lose on them, we don't deserve to be slammed with attorney's fees in this case, because those are all issues that deserve to be decided. Now, we think that when and if the case is reversed, that we will be able to prove the validity of our defenses. But assuming the worst, assuming we can't, these are still justiciable issues that any good lawyer would raise to protect a good client. The other thing I want to point out...
As an aside, I'll give you a little extra. Is this the Dave Oliver that is the Orlando lawyer?
No. The Orlando lawyer, David Oliver?
Right.
No, this is a New York David Oliver.
All right.
When the Orange County guardianship was entered, we said, okay, now if you want to put this money into the Orange County guardianship account, we will be happy to turn the money over and make this case go away, because then we will know that Paul Webb's money is being protected. And the answer was no, Thomas Webb wants it for himself. So we think all of these issues deserve to be considered, and we ask that you reverse it and let us have a hearing on the merits. But for all time, you would tell the lower court that there are many justiciable issues here, and attorney's fees are not appropriate.
Thank you, sir. All right.